Video discussion of the Land Revenue Act 1964, wherein I'll be specifically discussing to you with the powers of the government to grant the land under the Karnataka Land Revenue Act, and also one another important discussion I'll be making to you or I'll be discussing to you with is use of agricultural land for non-agricultural purpose. These two are again very important from the point of examination, wherein in these two cases again you are required to explain the procedures that the authorities follow in respect of the grant or conversion of a land from agricultural to non-agricultural purpose. The question can be, for the first part of this, the question can be like this: explain the powers of the government to grant the land under Karnataka Land Revenue Act. Of course, this can be also added with the powers of government to grant the land and relinquishment of the land under the Karnataka Land Revenue Act. Any of these questions can be asked to you with. Friends, back to this, we shall see this. The Karnataka Land Revenue Act, that is Karnataka Land Revenue Act 1964, even provides for granting of land to that of the individuals. And when we look at with this topic more or less speaks with the conferment of ownership in respect of the person who is in possession or who is in occupation of the property, again with respect to agricultural land under the Land Reforms Act, Karnataka Land Reforms Act. But the basic difference that what we have to understand, because the question can be even there under the land reforms, or also it could be under the Karnataka Land Revenue Act. It could be on any of these two areas. There we would be speaking, that is under the Land Reforms Act, we would be addressing it as the conferment of ownership of land. That is where the authority therein, of course Deputy Commissioner is there also, would confirm the land of what is already in occupation. But here, under the Land Revenue Act, we shall see that it is entirely a different process where it was not in possession, but the possession is being given, the occupancy right is being given to the person. That is the difference we make out between these two. Anyway, let me go with this as what is this grant of land under the Karnataka Land Revenue Act. As I already mentioned to you with, the state government is an authority to grant any such vacant land in favor of an individual. So in this regard, the state government can make effective rules or enough rules so as to make a grant, the terms on which the grant can be made, the persons who could be, for whom the grant can be issued. With all these things, there can be a rules that could be framed by the state government. So also, it can also delegate this power, or I can say authorize this power to such officers who could do an act on behalf of the state government. But literally, if you go with what is this grant, friends, we shall understand this, that this grant is really, it means a gift of real estate to a person. It is a gift which has been given by the government in respect of the real estate. Or we can also say in this way, it is that land which is being given to the use of the land for a person, or it is a privilege given to a person to enjoy upon the land. That is, either when it is being given by the government or by the authority. Or the other way we can say, practically if I am to speak with, it says like this: grant is something, an incentive which has been made by the government or by the authority of the government, enabling him to work on that land. Or we can also say, very popularly we come across with this, we can also say it is a form of rewarding for the services rendered. Especially, for example, you can take, or especially where if a military person, after his long tenure of his service to the country, he could be honored by granting him certain land. So in all this manner, we can see that the grant can be made, or we can understand those are being made a grant to the person. And again, let us say, repeat this again. That is, we generally consider, in general, we consider it to be as a gift of a real estate by the government. But in the other way, if we can say, the government or any other authority under the government, if they have given a land to that of your use, or for the enjoyment, or for the privileges that could be made out on that of the land, or if it is being given in the form of an incentive or as a reward, if it is being given to, then we shall say that the grant is being made. That is, the land is being given to on grant. So in this form, we can see the grant can be made. And again, I would like to repeat, I am insisting and again stressing on the point is that it is always made to the individuals. The grant is always awarded to the individuals, not to the organization or not to the sector. That is, the land can be also given to religious institutions. Generally, when we are speaking with grant, we may have a grant given to that of a religious institution or the socially backward class of communities for the purpose of their community. All these things are there. But when we come back to the land revenue addresses upon the grant given to that of the individuals. And in such case, that's what section 91 goes with. The government has a power to make such rules or impose such regulations while providing this grant. And the deputy commissioner may also in such case require upon the individual to pay such price for an unalienated land or for an unoccupied land, or also, my friends, we can see that he can cause such sale of the property by way of an action with such condition imposed upon that of the grant of land as it deems fit. In a way, I can say, that is, on the powers that is being conferred to the deputy commissioner, the deputy commissioner do also have this right. That is, I was saying you at the beginning, the government or the authority, we say. When authority is acting, though we don't exactly call him as an agent of the government, but by the authority given by the state government, he would be acting on behalf of the government. So this deputy commissioner shall also have a right to proceed with granting of this land. That is, the grant can be taken place by way, as I again like to mention this, that is, by you requiring to pay the price on that of the land, that is, of the land which is being unalienated, and the land where it belongs to that of the government, where no owners are being assigned to with. In such cases of land, the land can be granted by paying you the price on that of the land. Or where if the land is said to have been a land which is unoccupied, then such lands can also be given to with, or even those can be made by way of sale in action. But in doing so, he can impose any condition which would be necessary at the interest of granting the land. So in that way, this way, my friends, we can say that the grant can be made with. But in taking the possession of the land, it says that before you could go to the possession, before you could take the possession of the land, there shall also require a permission of occupancy of that land. In such case, what it calls for is the price for such land shall be included, and the price has been assessed by the government shall be paid upon with, and while assessing the price for that of the land which is being going to be granted to you shall also include that if there are any trees in that of the land, then the number of trees are going to be calculated. And also we see that if there is any such thing which can be recoverable, then those can be also assessed, and it could be imposed with the price of uncalculating on all those things like trees or any structures that is being made out in that of the land. Those things will be made. And having made a grant to the person is required to pay the money on this, or pay the price on this, or should agree to pay the price on this, or even you can go in the form of the arrears that could be paid on the future date. And mind this, where it is an arrears that which becomes payable on the part of a person to whom grant is being given, then such a amount of arrears, what is payable, can be collected by the government in the form of arrears of land revenue. So in this manner, the grant is going to be granted to the person where if the land is unoccupied or where the land is vacant and that belongs to the government. Not only this kind of land, my friends, there could also be a grant of land with respect to an alluvial lands. Alluvial lands means that is lands which are being newly formed, maybe because of erosion or because of the storms. That could be a land, the sand could be deposited on a particular place, and there could be a large amount of land which could be created in, or it could be formed in. Or we can also say like this, that is an abandoned land on the river beds or river banks. If those lands are also considered to be as alluvial lands. And if these lands are to be made, in fact, these lands which are formed of themselves, newly forced or newly formed land, or where it is on riverbeds, these lands are also belonging to the government and the right would vest in the government. So the vested right of those land would be that of the state government or the concerned government. So in such cases too, the deputy commissioner, as far as possible, he may also proceed to alienate the land or give the land that is alluvial land, that which vests with the state government. And the commissioner in this regard, that is deputy commissioner in this regard, shall also look down to the public interest. That is, taking the public consideration, interest, the deputy commissioner looking to the interest of the public revenue also, he can dispose of any such land what is necessary required, or the alluvial land which has been formed upon with. And the price of this land shall be not more than 3 times of the annual assessment on that of the land. That is, where newly formed land is there. So when you are going to cause a sale of that land, it should not exceed more than 3 times of the assessment value. That is annual assessment value. Annually, if you take, the assessment would be made on the basis of that. We would be fixing that this would be the amount of value of the land. So when you go on the assessment of this, that it could weigh with this annual what you can gain or what you can come out with it. On the basis of that, the fixation of the amount shall also be fixed to that of this land. And where after the grant is being made, or in the course of such grant is being made, if a person to whom the grant is being given refuses to deposit the payment, then the deputy commissioner shall also have a power to dispose of the same without any restriction thereof on that property. He has a right. And that's what section 93 also says, where if any person, if he occupies the land, which is unoccupied, that is before he entering into the land, whether without getting the grant of the land, then it is the duty on him to go before the Tahsildar, obtain the permission of the Tahsildar, that he could go for obtaining the consensus of that person in the jurisdictional area and then occupy the land. I repeat this again, that is, if the land is said to have been occupied, or if it is not in the occupation of that land, that is of which the deputy commissioner has granted to you, before you going to have an occupation, you have to obtain a permission, especially with the alluvial lands I'm speaking. You have to obtain a permission from the Tahsildar concerned, that is from the concerned jurisdictional area, and thereafter you can go for the occupation of that land. And there again, the state government also has a power of framing such rules in this regard, or impose such conditions upon you while taking the possession of the property. And the Tahsildar is also having a right to grant any such person in this regard where he finds it desirous to do so. And the copy of the same, that is the government, and it can impose a condition, it can impose a rules, and with the powers that is been granted by the government, the Tahsildar also have a power of giving upon with this right. So in this way, my friends, the grant of land can be given from one person to the another, that is the state government has a power. And if you read section 94 of the act, a person, if he unauthorizedly enters into the land without for any special purpose, that is, if the land which is said to be called as an unoccupied land, or if the land which has not been alienated, And if that land has been unoccupied without any such grant or without any such permission, either by the deputy commissioner or by the tahsildar, then my friends, I'm speaking in general there, it is whether alluvial lands or the general lands that what we see, or common agricultural lands what we see. If a person is in occupation or enters into the land, uses the land, then he can also be imposed with the penalty. That is, which says where a person who occupies a land and use this property for the agricultural purpose, then the imposed, that is, he could be charged with the amount, and the recovery of amount can be made, that is twice of the amount of the assessment for each year. That is, for each year what could be assessed from out of the property, of that assessment he can be asked to be paid with that money of what he is using the property which belongs to the government. That is one imposition he can make. And the penalty what he can impose to this is that, again I repeat, the two kinds of liability who's be imposed against a person who is under an occupation without having an authority. That is, a person who without occupation, a right over the land, or without any special purpose, if any such person, if he has occupied the land and those land which has not been alienated by the government, then in such case the person is required to pay the twice of the value of the assessment that could be levied against such property. That is, in calculating the assessment of that which could be paid to the government would always look down to the same similar kind of the property within the same village, and how the assessment is taken on that of the property in the same village, the same can be imposed, or the same criteria can be adopted, and that criteria, having adopted that criteria, twice of the amount of that could be given to the assessment, and it could be charged as a revenue which is payable on that of the unoccupied, that is unauthorized use of land. Apart of this, the penalty can be imposed. The penalty is this, that is, the deputy commissioner can impose the penalty to the extent that where if a person is using the land for the purpose of an agricultural purpose or for agriculture, then the penalty can be imposed to the extent of not more than 500 rupees. Of course, I believe this could be also changed now. And if the same were to be for a non-agricultural purpose, where the land is used in and around for the agriculture, but if a person has unauthorizedly used this land for any other purpose than that of the agriculture, then the penalty can extend to 1000 rupees. So, addition to the assessment and revenue what is payable on him, the deputy commissioner shall also have a power of imposing him with the penalty. So in any such case, my friends, we shall see that the grant of the land can be made by the state government through that of the deputy commissioner. In the likewise, we shall see that is the person who is holding the land or who has got a land by way of grant under section 95 shall also have a power of relinquishing such right. That is the government can take back the land, that is for the purpose of which it is being given to, if the same is not being put to the use of the purpose in which it is provided with, or where if any such defaulting act is being committed, then such person shall have a right to relinquish the land. That is, the government can cause a notice to that of the person. On such notice what is been made, the person can go relinquish the right in respect of the land what is using. Or if no such act is being made, then the government shall have a power of the forfeiture of the land which is in possession. So in such case, my friends, we shall also see that under section 95, a part of the grant of land, what we see, we shall also see that there could be a relinquishment of the land which could be made against the property which is in the occupation without the authority. So this is one with respect to the grant of land and a small extent to the relinquishment of his right. Once when relinquishment is made, the land vests with the government and all those encumbrances which would be on that of the property shall vest with the government, and the government would have a right over the property, and in the course of this the government shall also have, that is whether it is a forfeited property or whether it is a property which is been acquired by way of relinquishment, these properties can be further granted to any other person. So in this way, my friends, we understand what is grant, and again I repeat this is an important from the point of examination, a common question which could be asked in this regard. They may articulate the question in any form, in any manner, but you should be in a position to go with this. The next comes is use of agricultural land for non-agricultural purpose. Again, the question in this regard is, they may ask you, I'm just giving you a direct questions on this, but it could also be reversed, or it could be tactfully asked to you also. That is, the question is, explain the procedure to be followed for conversion of agricultural land into non-agricultural purpose under Karnataka Land Revenue Act. So when this question is asked, we shall see that, sorry, I was seeing you mentioning here, that is from 95 to 97 goes on this part. That is how conversion takes place. 94 was the relinquishment of land we were discussing too. That is, they can also go for relinquishment of land, but 91, 92, 93, 94 goes on with the grant and relinquishment of land. But when it comes to the use of agricultural land for non-agricultural purpose, then it is from 95 to 97. Friends, when it comes to the use of agricultural land to the non-agricultural purpose, first we have to understand that when a land is set to be put in for non-agricultural purpose, or when a land is said to have been used for non-agricultural purpose. This is what we have to understand, and when the use of this can be made. This is what we are going to discuss here. See, when we discuss on this issue, we understand in this way, my friends, the owner of the land, the occupier of the land, or any person who is said to have been a tenant over the land, or any person, again I repeat, who is in occupation of the land. That's why we say owner of the land, occupant of the land, tenant on the land, or a mortgagee on the land, shall have a right of erection of a building in that land, or have a right of construction of any wells, tanks, or he can also do this for the use of agricultural purpose. Sometimes it could be also for the benefit of him or himself, or to that of the servants or tenants or agents or any other representatives of him. That is, for the benefit of these people, he can do any such act like construction of wells, construction of building, construction of house in the land. These works can be done. Or also we can say, he can also make any such improvements for the better cultivation of the land. That's what even the land reform speaks with the improvements under its definition class. He can do any such improvements for the purpose of cultivation of this land, which would be more convenient for the person to have a necessity to do so for the purpose of carrying the agriculture. And that is what we call it as improvement. Like I can say, a person converting the dry land into an arable land does several works for the purpose of conversion. Or a dry land, or a land which has been a mixture of stones, in order to make it as an arable land, he collects out all those stones and fit it for the cultivation. These things can be done by him. But in doing so is permitted also. But what it calls here under this proviso, that is from 95 to 97, is where if the land is assessed, or where the land is being used is diverted for the purpose other than the basic or the main use of which it was being put in, then my friends, the question comes is whether there is a conversion of a land from agriculture to the non-agriculture. I repeat this, my friends, where the land which has been already assessed, that is, when there is a Land Revenue Act, it has been assessed saying that this is an agricultural land, this is the land, that is records of right also says these are the crops which is been growing on this land, or the plantation of such kind is being made in. Sometimes we make ragi, sometimes we may make wheat, sometimes we may grow rice, sometimes we may grow sugar, like and like forth, my friends, such forth. That is, the records of right also speaks upon with that. And when it speaks upon with that, if that land is diverted for the other purpose, then we shall say that the same should not be made. And if you are converting the land for any other purpose, you can use it for agricultural land. You can use, it is not that when I am growing wheat, I should grow only wheat. When I grow rice, I should be growing only rice. Not that. You can use the land. You can use the land for agricultural purpose. You can use the land for the plantation crops. You can use the land as a garden land. You can make it in any form. You can make it in any form, but that should be used for agricultural purpose. But where the land is not used for agricultural purpose, and if you want to have a deviation in respect of the use of those land, then you should first apply it to the Deputy Commissioner for the permission of the Deputy Commissioner. And the Deputy Commissioner shall also grant such permission where if he finds necessary that or where he thinks fit that it is required for the benefit of everyone. So in such case, because as soon as we say Deputy Commissioner, land is a source of improvement, The land should not be stagnant, it should be changing. That's what the basic objectives of any land for that matter. It should be changing. That is, it should change from one hand to the another hand. It should change from one kind of activity which is conducted to the other activity of the land which is going to be converted. Only then we can see the improvement. Otherwise, it is not. So in that regard, I am speaking to you with this, my friends. The Deputy Commissioner, where he is satisfied with this, with the conversion of the land, then this Deputy Commissioner can grant you the permission if he finds satisfied to that of the permission or diversion what you are speaking with. But in course of this, you have to also specify for what purpose the diversion, for what purpose of use you are going to put that by way of this diversion shall also be specified. On the basis of this, the Deputy Commissioner may grant you the permission, or as a things fit, he may grant you the permission. And it says this, when I speak to you with this conversion of this land, it also says that a person is also liable to be registered as a person under section 48A of the Karnataka Land Reforms Act. Is also liable to make as an occupant of the land, is also liable to make this. Or also it says that the grantee of the land under section 77A of the, or 77 more particularly, which of the Karnataka Land Reforms Act shall also have a right of making an application for the conversion of this land. That is, diversion of his land for that of the non-agricultural purpose. Where if such land as sought for the conversion, or where such land therein, or part of the land therein, if he wants to put for other than that of the purpose of what it is being given to, that is for the non-agricultural purpose, then this Deputy Commissioner, after having given notice to the person on this behalf, or as in a prescribed form that by the Tahsildar, and paying the prescribed fee, he shall go seek the permission of that conversion. That is, he can first make a notice to the Tahsildar, and through that of the Tahsildar, we can see that after paying the prescribed fee on that regard, whatever the amount that is being required to fee that is to be made for the purpose of conversion, we shall see that the same shall be, after having given notice, the permission can be accorded for the conversion of those land, or divert the land for other purpose. So in such way, we can see the conversion of agricultural to non-agricultural takes place. But where the Deputy Commissioner, in the course of a permission sought for diverting of the business or diverting of the use of the land, if the same is being refused by the deputy commissioner on the ground of this diversion, saying that this diversion is going to likely to cause the public nuisance, or he may also say that this diversion is not in the interest of the general public, or it may also feel sometimes that this person to whom diversion is sought with, or diversion is made with, seeking for the diversion, permission for the diversion, is such person where the occupant or such occupant is unable to carry upon such diversion, or unwilling to comply, where a person is unwilling to comply with the conditions that are being imposed by the deputy commissioner for the purpose of this diversion, then in such cases, my friends, the deputy commissioner shall also have a power to reject upon your diversion. He may refuse to give you the diversion, and the decision of the deputy commissioner in this regard stands to be final in nature. So also, in determining the amount as to the occupation of a person, suppose say if a person is in unauthorized occupation, or if a person has already started using for any other purpose, then in such case the deputy commissioner shall also impose him a penalty, and he can also take the portion of the land for which the diversion has taken place. And in considering with this, my friends, if any such diversion has taken place, maybe in the diversion of agriculture or any other purpose, then it should be considered to be as for the whole year. And any crop including trees that is raised on that of the land shall be liable for forfeiture, and also shall have a holding of land which is being removed by way of forfeiture because of the diversion which has been made by him without the permission. So in this way, my friends, the deputy commissioner can refuse you for granting this land. But on the other hand, we also see where if the deputy commissioner proceeds for having given the permission, then he can also impose the diversion order to secure the health and safety of the person, to the convenience of the public. He can do this. He can permit. Suppose, say, if a person comes up saying that I want to construct a public health center or public health office or public health hospital for the purpose of benefit of the villagers, and he wants to convert his land into the non-agricultural purpose, that is, his land to be converted into an hospital, wherein for the purpose of having giving out all the dispensary works or dispensary facilities, then we can also grant the permission. So we shall see that the condition imposed by the task, that is by the deputy commissioner, shall be made, and the condition could be in respect of securing the health of the person, the safety of the person, or the convenience of the person. But where if the same is found it is not contravening with any of the provisions of this law with respect to relating to that of the town, country and town planning development, or even with respect to the erection of buildings, anything as that, if it is not contravening to any of this provision, then the deputy commissioner shall have a power of granting this permission. And mind this, my friends, when I make my application before the deputy commissioner for converting my land into a non-agricultural purpose, then on the requisition made, maybe through the notice of the Tahsildar, if I make a requisition to that of the deputy commissioner, then the deputy commissioner is required to inform about with the same to the parties within 4 months of time. That is, on the day from the notice of the application made to the deputy commissioner, from that day within 4 months of time, it is the duty on, that is, from the date of receipt of the application I am speaking, it is the duty on the part of the deputy commissioner either to accept such conversion on which an application has been made, or refuse upon such conversion. If he accept within 4 months of time, he can go grant this application for the purpose of the conversion what has been sought, and maybe the further requirements can also be called, the further procedures can also be required to be followed with payment of that is payment of revenue or payment of fees on that, payment of development charges, all these things comes there, you can be asked to pay upon those money. But where if the deputy commissioner has failed to give the information or has failed to accord the permission even after the 4 months of time, then it is understood this, my friends, that the permission what is sought by the person is deemed to have been granted by the Deputy Commissioner. It says that is you are required to go within 4 months, otherwise it is deemed to have granted the permission, unless where the Deputy Commissioner shall at the instance or otherwise direct the applicant to be recognized that he shall be an occupant and shall continue for the same thing, or he may have given with further notice with the compliances of certain requirement. Unless that is being made, it has to be satisfied within 4 months of time. And one important question we can also see under the area is, or we should understand here is this, my friends. See, these are the general discussions I am making to in all the others, but there are certain special classes of areas wherein it is considered with. See, it says that where especially if a land, agricultural land, in the areas of Dakshina Kannada district, Kodagu district, and the ಕೊಳ್ಳೇಗಾಲ district of Mysore division or Mysore area, where such land is said to have been diverted by the person, that is by the occupant, for this purpose, maybe I like to say, if he has been diverted to some extent, for the purpose that is from the day of the commencement of the Karnataka Land Revenue Amendment Act of 1981. I repeat this. That is, if the said diversion has taken place before the Karnataka Amendment Act of 1981, then the land apperent, that is which is attached to, if the same is not exceeding 3 times of the area. When I say area, my friends, that is, it speaks upon the built-in area. If it is not exceeding, that is 1/3 of the area. In fact, I can say that's what it says. 3 times of the built-in area shall deem to have been permitted, and they are required to have an use of this land for. We can not say that they are being used for other than the agriculture purpose. However, my friends, we shall not bring the same into the definition of this class, that is the farmlands. Farmlands are excluded from this, but if the land in any of this part, that is Dakshina Kannada, Kodagu and ಕೊಳ್ಳೇಗಾಲ area, if the land is being used for any other purpose, that is wherein the built up area of that land is 3 times that of the building area is concerned, then those cannot be considered to be as a deviation, provided where this has been caused before the Amendment Act of 1981. Subject to this, in all other cases, my friends, we shall see that the land is said to have been deviated themselves from the use of agriculture. And the Deputy Commissioner may, in this regard, my friends, that is especially with the use of agricultural land is concerned, that is use of agriculture to non-agricultural land, can make such rules made by the state government and may require upon a person to pay such fine, and it also includes not only to that of the owner, but also includes, as I was speaking in my previous discussion, that with the mulangidars, it also includes any occupant who is holding the land has a mulangida or a permanent tenant which is in occupation of the land. This is one another criteria. And for this also, if the conversion has taken place by the person without any such permission of the Deputy Commissioner, then a penalty can also be imposed against such person. That is, where the land is converted or where the land is being put into the use of other purpose without the permission of the Deputy Commissioner, and even after the expiry of the period of the Deputy Commissioner, then the Deputy Commissioner can summarily evict the occupant of the person who has caused for the diversion of such land. He can remove the construction what has been erected by giving a notice to that of the person, and the Deputy Commissioner shall also have a power of passing any such orders which he would be reasonably considering, and he would be reasonably also thinking for the removal and for the forfeiture of the same. So that the Deputy Commissioner can also pass such suitable order. He can proceed for removing of a person, removing of all those erections, removing of all those buildings, and he can even proceed for forfeiture of those property which is being converted. Maybe say for example, if a land is being granted for the agriculture purpose and if I am using the same for agriculture, the Deputy Commissioner shall have a power for having even forfeiting the land of the same what has been granted. So also the occupant who is in the land and the person that is occupant or the person who is responsible for such a diversion be liable for such diversion as a penalty of not exceeding 1000 rupees. I think this is again now to be changed with. It says that it shall be a penalty which can be imposed, and the land assessed for the agriculture, if the same is being diverted, then the Deputy Commissioner shall cause a notice to the person, directing the person to, that is within the reasonable period of time, he shall bring back the land which is converted for the original status, that is for the agricultural purpose. And he can also make his observation and impose the condition that whatever the changes that has been made in the land should be brought back to its original position. Suppose he might have removed the sand from that of the land, agricultural land, or you might have taken the land from that of the other. So then in such cases, the Deputy Commissioner can also order the person to fill up those lands or fill up or make such land which would be reasonable for the use of agricultural purpose. Apart of this, it can also be imposed with the fine, as I said, again with the 1000 of rupees. Where if a person, even after such penalty imposed, even after such direction given to, if after the notice is being made, if he fails to go with that of the notice or fails to take the steps in respect of which the conditions so imposed by the Deputy Commissioner, then the Deputy Commissioner, he himself can take an action against this, or he can take steps in this reason and cause to see that there shall be a recovery of that of the cost what is incurred in respect of this conversion again, that is putting back into its original status. That is the Deputy Commissioner may himself take the action in this on the failure and impose, that is he can extend the cost whatever that is being incurred by him in respect of the same in having reconverting back to the agricultural purpose, and the same can be collected as a land revenue from that of the person. So this is how, my friends, we shall see that the agricultural land can be converted, and the restrictions are also equally there where an agricultural land is going to be converted into the non-agricultural purpose. So this is how we see, that is right from 95 to 97 we shall see that the conversion of land goes on with. The another important discussion I have to go here is with the records of right, a very important from the point of your examination too. Of course, those topics what I am discussing is only from the point of your examination, and those are important. I am just discussing with those areas. Friends, the next comes, as I that said, records of right. In Kannada we say it as Akku Dakala Patra anta heltivi athwa Jamabandi anta kuda heltivi. Section 127, 128, 129 speaks specifically with what is this records of right, but basically we can say that section 127 to 136 of the Act speaks with the records of right. What is this records of right? See, as soon as we say records of right, it is something, a document which is being issued to a person or which a person holds, has issued by the authority, establishing his right in respect of the land what is holding, or in which is in occupation, or in which he is in cultivation. So any rights which establishes to a person or persons has in respect of a particular land or a particular estate, then such is said to be called as your records of right. The records of right includes your RTC, covers RTC, mutation and also patta book. Covers, that is right transfer certificate, because many of my friends sometimes will be asking what is RTC. With this, normally people will misgo with this, considering that it is called as records of right. No, this is right transfer certificate. This is what we see. It includes all these things. But in general, if you look upon what is this records of right, I can say you, my friends, it is a document which is being maintained for each and every village of that tahsil in respect of every estate. I repeat this. It is a document which are being maintained for each village within that tahsil, that is within that is jurisdiction of tahsildar area, within that village, in respect of each and every estate, containing an information as to the name of the owners, the area of which, that is the area in which it has been put under cultivation, the share of the owners, and other rights are decided there, or it has been specified there. And also in this records of right, there is an assessment of land revenue payable on that of the land. So any information which I can get in is nothing but we shall call it to be as records of right. So there is a collection of various revenue papers. I can only say in this way. That is, records of right is a collection of various papers of which the estate is regarded with, or in respect of the estate as regarded with. So all those documents, various revenue papers, what is being put in is said to be called as records of right. In every panchayat village, that is in every tahsil, we see that records of rights are being maintained with. It is maintained with who is the, that is, it says that is who is the owner. When you go with the contents also, we can say who is the landowner of the property, whether the landowner is himself having cultivating the land, or whether the land is entitled to be, whether the owner is entitled to receive any rent or profit provided in the estate. Is he doing so, or producers, is he doing so with respect to the sharing of profit, or producers it could be. Extent of a person who happens to hold an interest in that property, who is in occupation, the rent that is payable on that of the land, the land revenue rates on that, cess what is payable, rates of revenue that could be levied upon, other payments if there is anything there that is being mentioned. So also the rights and liabilities in that of the estate that a person might be having, the map of the estate, all these things are there as a contents of this land records of right. A part of this, we shall see that in the hands of an individual, we come across saying that it is, these things are also being made. Now, what is this other part of the things? And when I say with this, my friends, see why when you go with the object of this records of right, it has a very strong influence on the collection of revenue, I can see. It has a very strong influence. See, what is the government always wants? Right from the kingdoms, whatever that we see. Even if you take the instances of the Ramayana and Mahabharata, the kings who used to rule, that is Magadha or whatever the states that they were ruling in, everybody aimed at having collection of revenue, that is collection of rents. They used to call it as sunka, that is they have to give it as a revenue to them. And that is the aim of the government also today. See, the government also looks in to either share the producers of what you have grown, maybe in the terms of value of money, where by the person who is in permanent occupation, or if he is in occupation of the land. So in determining what shall be payable by a person from the belonging of the land, it is necessary to have a necessary records on that. And this necessary records, or the records what has been maintained, would determine what is the profit of a person to whom it is belonging to. And a part of this, my friends, that is showing the necessity of records, it also gives showing you that throwing out or showing you out the responsibility of a person who is in possession or the owner of a person to the payment of land revenue. So that payment of land revenue, to show the payment of land revenue, records becomes necessary. Like when the land revenue is being paid, for how many years the land revenue is paid, what amount of the land revenue is paid, what is the production, all these things would be made upon with. So in a way we can say this, my friends, records of right is something, it is a sound system of collection of land revenue by the government. A sound system. They have a particular system wherein which the system through which they can collect the land revenue, and how to collect this land revenue basing on the information, what the land is in, how the land is in, for what the land is being put in. On the basis of this, my friends, the government shall have a part of having collecting the revenue. So all those information what you get is said to be called as the records of right, which includes RTC, mutation and patta book, which includes this. Because even these are the documents issued basing on the records of your right, it is being issued by the appropriate authority to the persons. Now we shall also go what 128 says with. It gives out an acquisition right to be reported with, which says that is any person, if he happens to acquire a land by way of succession, by way of survivorship, or by way of inheritance, or partition, or by way of purchase, or mortgage, gift, lease, or in any otherwise manner, that is interest, or by way of relinquishment, or by way of restoring back of the property, or in any of this manner, if a person do acquires a right over the property, then such officer, he has to inform to such officer, and the officer of the village shall have a duty to attend such and transfer that is being made. Then within 3 months of time of the date of acquisition shall be made with a written acknowledgement, and the receipt of the report of the same to the person making it should be given. That is either the Tahsildar or the revenue officer to the same, that is on the receipt of which the acknowledgement is being made to the person who is making it or taking it, that the report has to be made within 3 months and it should be entered in the registry. That's how we have a system that as soon as the registration, that is under the Indian Registration Act, we see that once when any property is being registered in any manner, within 3 months of time, it has to be complied, and the notification shall be made with that of the person, and it should be entered in the registry of concerned department. So it says that, so once when an acknowledgement is being given to you with, or the receipt of such is being made, the report shall be made by a person who is making upon with. And it also includes, my friends, that is, it says if a mortgage who happens to, that is if a mortgagee who happens to hold a position of a property, then he need not, otherwise we can say it also includes a mortgager who happens to make his property mortgage or give his property mortgage without a position over the property, but does not include this transfer of interest. What I am speaking does not include to state upon where any transfer of interest in the form of easement, or where if it is a creation of charge not amounting to that of the mortgage. If this is there, you need not have to go or report the same. That is, in a simple manner, if I am to put one, if there is any easementary right over the property, then that need not have to be disclosed, nor if there is any amount which is going to be charged, that is, if a property is going to be created with a charge otherwise than that of the mortgage, then you need not have to report the same. But otherwise than this, you have to report for the same. We have a process. Maybe I may feel that practically I may feel that when I take her, when I alienate the property, when I purchase the property, I will not be going for information. Now, because of this reason, we see that the department themselves undertakes to go report the same to the concerned department with respect to that of alienation. But however, we say that it is the duty to do so. It says that where a person who is making a report after 3 months of time, that is, you are required to make a report within 3 months of time. But if a person who is making a report after 3 months of time, but before 1 year of time, then the report what has been made shall also be received with the payment of penalty. Of course, then it was 2 rupees. Now I think it is being changed. It says that 2 rupees was the penalty then it was imposing. But it says that is also required to pay along with the penalty, where if the report has been made after 3 months then to 1 year, that is within the gap of 3 months to 1 year. But where the same report has been made after 1 year of time, that is any time, in number of days it could be, then it is 4 rupees of the penalty, twice of the penalty of what can be imposed as a penalty within 3 months to 1 year. So twice of the penalty can be imposed in making a delay in filing the report to the concerned department for its corrections. So any person who is acquiring a right as a holder of that land or occupier of that land or as a owner, etc., 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 shall pay also the registration fee for making this necessary entries, and on that, my friends, the same shall be entered in the records of right. We also see there is a registration of mutation, that is where the registration is been disputed. It says that is where if any officer who enters into the registry of land, who gets into the registry of mutation, at the same time if the registry of mutation can also be made by post, and that is, if I can put it in this way, sorry for that, my friends, when it comes to the mutation is nothing but which is a recording of transfer of title. That's what we call. So when any such title is going to be transferred with, or by any way, by lease or mortgage or by creation of charge in the form of mortgage, or in any manner, if there is a creation of right of title has been made, right of interest is been created, then the officer who is in charge shall enter in the registry of mutation. At the same time, it is also necessary that registry of mutation shall be made through the post to the same concerned village, and the same shall be specified at the conspicuous place. That's how we see it should be in whatever the best possible manner that you can state upon with the creation of interest in any of the land shall be notified, or it can be notified, the same can be made. That's the commonest way is this, that is pasting it at the conspicuous place of the panchayat area or at the chavdi, who shall give a written information to the all persons who it is appearing there, and that would be also entered in the records of rights of mutation, or person who is interested, him shall also be given with the notice of this. So in this way, my friends, we shall see that the records of right can be made. As I was saying you with this, my friends, there is also a RTC. That is, on the basis of this records of right, we shall see the RTC can be given, that is right transfer certificate, which contains 16 columns in itself, which would says this: what is the kind of property, who is the owner of the property, who is in occupation of the property, what is who is the owner, who is in occupation of the property, or who is the person who is plowing out or causing an irrigation of the property, or it may also contain what is the area of the land, what is the land revenue assessed with, all this information, like if there is any change in the encumbrances, then what is the change in encumbrances, all these things would be specified for each and every year. That's what we can come across in RTC. When it comes to the mutation, my friends, mutation is again, as I said, it is a document which is which shows the transfer right of title of a person, or if there is any transfer of title or interest of any person in respect to that property, that would be registered in the form of mutation, which carries 7 columns in head. It carries 7 columns as to who is the person, who is the owner, who was the occupant, from whom the transfer has been taken place, what is the fee that is being paid on this. All this would be entered in the area of mutation. And when it comes to the patta book, this is what is more required for us, because quite oftenly asked for examination, especially mutation and patta book is always asked for the examination for your short notes. Quickly on this, see, a part of this, my friends, under section 129A, we see the holder of any agricultural land, including the tenant for that matter, primarily liable to pay the land revenue. Is it? So, when he is liable to pay the land revenue, he is also being supplied with a prescribed book or in a form of a book by a prescribed officer, called to be as a patta book. That is a book form, in unlike the previous days we used to have a ration card, or nowadays we have a vertical kind of the passbooks in the bank, but those days we used to have a horizontal kind of passbooks. In the same form, horizontal form, the patta books are going to be issued with, which is containing the copy of records of right, or that is pertaining to such of the land. This book shall be supplied by the prescribed officer themselves, that is in every village panchayat. The village panchayat would prescribe and would give upon with this a book for the purpose of all those entries which they are making in. In fact, when I pay the land revenue, when I pay any, or when I cultivate any such land or any interest therein, if I take any loan, all those things would be entered in that of the patta book. So we can say this, my friends, it is a book which shall contain an information regarding the payment of land revenue, or in respect of the land, or whether the state government dues are there in respect of the holder. Such would also be specified that what shall be the dues in case of any tenant, and any information in respect of the cultivation of the land is concerned. Who is the tenant? What is the kind of cultivation that the land is being made, and what is the area of crops that is being sown? Suppose if I have 5 acres and if I am cultivating only 2 acres of land, what is the area of crops that I am sown in that land? Which will be shown in the, as shown in the village records, would also be entered in the patta book. So sorry for this. So a patta book shall be prepared, issued and maintained in accordance with the rules that is being laid down by the state government, and in this behalf the state government shall also have a right of collecting the fee, or the fee shall be charged upon in preparing this patta book and for the maintenance of this book. So in a way we can say that this is a book containing a statement of records of right, the mutation entered in the register, that is where the transfer has taken place, where if any interest is being transferred. So information to all these things would be specified in this patta book. So this is how my friends, we shall see that the patta book is also required to be maintained by that of the person. So this is the few discussions with grant of land, use of agricultural land to non-agricultural purpose, and even with the records of right. Purpose. Now we would be discussing what the determination of boundaries and boundary marks, etc. See, when it comes to the determination of boundary marks as such, the boundary of every village, or we can say the survey numbers, or the subdivision in the survey numbers, or by its holding, shall be fixed. It shall be fixed. That is, what is the number of, what is the extent geographical area that a village consists with, how it is being mapped out with, how it is being subdivided, how the survey numbers are categorized in this, how the subdivision of those survey numbers, how far the holdings in those subdivisions are also to be categorized very clearly, and it should be marked upon with. That is what we call it as survey. And if there is any dispute relating to that of this, then the same shall be determined by the survey officer, who shall have an authority in this, or by any other such officer who is being appointed by the state government in this respect. So in that manner, the survey of any such land, or the boundaries of any such land, is going to be determined upon with. And when it comes to the determination of the boundaries of land forming a survey number, or maybe on its holding, that's what we look upon, because the rest is how villages is going to be made, that is also there. How village boundaries are going to be fixed upon is also there, but we will be concerning more about with the boundaries of the land forming and the survey number on the basis of their holding. At any time of the survey that is being conducted, or the boundary that is going to be made of the survey number, or subdivision of those survey number, or the holding, it shall be determined on these criteria. If the land is an undisputed one, there is no dispute on that, then it shall be recorded with and marked on the point of the holder who is happening to hold a land by the person in his occupation. Because basing on these records, I was speaking to you with also the records, basing on the records, basing the map of which that each person is holding an extent of the land on the basis, that is whatever that is being given to you under the records, that is the records, what we see, records of right. On the basis of that, the total survey would be made. Suppose, say, this is the survey what I am having over the land, and when the survey is there, this is the geographical area of the survey what could be marked in this village, and in this village there could be several survey number, and this survey number can be a subdivision numbers of those survey numbers, what we call it as ISA, and of which what are the number of persons who are holding the lands are also looked in. Holdings are also maybe something like this, it could be partitioned like this, something which could be, or it could be something like this, it could go on this. All this are the parts of those land. So that would be determined. If you don't have any dispute in respect of the land what has been recorded, or the survey what has been made, or the survey of what has been marked out by the holder as an occupant, then the land what has been surveyed and fixed as the mark of those land, and the person who is in such occupation within that of survey number is said to be called as the mark of land. That is the boundaries of the land. That is as pointed out by the holder, the person who is in occupation, that would constitute to be the survey number of the area. This is how we go upon with. But if the same were to be in dispute, if there is a dispute made between the parties with respect to the holding of the land, maybe some person comes and says that, usually he comes and says that the person is happened to hold more land of that what he is entitled to. Or there is a dispute which saying that a person has encroached my land in which he is not entitled to, because each one has been divided into subdivisions. So if there is any encroachment of the land, then the surveyor can hold an inquiry in this regard, and basing on that of the records what has been made, that is records of right, that is in which they have, or the map in which they have, basing on this, my friends, causing a survey on this, making an inquiry in this, they can fix the boundary mark as they consider after the inquiry. That is, as considering necessary, they can go upon with this. So if a dispute has arisen and which is not been surveyed with, but then after the completion of survey, or if the dispute has arisen and no survey has been made, or even if survey has been made and later on if the dispute has arisen in this, then the Tahsildar shall decide upon the dispute as between the land records are concerned. With regarding to land records as concerned, that is affording to the satisfactory of that of the evidences which is being placed in respect of those of the boundary marks, or with that of the previously marks that is being fixed, and considering all those, or causing such inquiry into this, the Tahsildar shall have a power to determine upon the boundary marks. So this is one way of deciding upon as how the boundary marks are going to be fixed upon with. But apart of this, we shall also see there can also be a settlement of the boundary marks, or settlement of the land. We shall see that how settlement of the land takes place with. This is again an important question from the point of examination. They may ask you a question saying that what is, explain the term boundary mark, or how boundary mark is being assessed, or how boundary marks are going to be fixed, and what are the ways in which the settlement of boundary marks can be made. This is how they can say settlement of boundaries. They can go away straight away with this question. They may be asking you for the examination. That is 137, 138, 139, 140, all this goes under this. Now, how the settlement of boundary marks can be made. See, quickly let me go with this settlement of boundary marks. That is, one is by agreement. See, it so happen like, if it is a case of village as a thing, in case of a village, if the villages have a dispute in respect of the boundary marks of the adjoining villages, or if the dispute is with respect to one or more panchayats with respect to that of the area that what they are holding with, or the boundary mark which is common line of boundary is being given to them, and if they have a dispute with respect to the concerned villages, then the officer on the basis of a record making, that is having recording the same, get duly signed by the chairman, the vice chairman, and also the members of panchayat concerned, they can make or they can carry out in the manner of agreement. They can enter into an agreement, and on the basis of this agreement, obtaining the signature of all this chairman, vice chairman, and members of the panchayat, they can frame or they can divide the boundary marks, or can they settle out the disputes in respect of the boundary marks by way of an agreement. Something like this, what we call it as Kajinaya, we call it as, in such form, you take this part of the area, we'll take this part of the area, this part whatever in excess you have, and that part whatever that is there, we'll give it to you. In this way they can make out certain arrangement of themselves, and thereafter they can go with making a settlement. So by way of an agreement entered between the parties, they can proceed with. That is, in case where if two or more adjoining villages or two or more panchayats, if they agree to fix the boundaries, I repeat this, if they agree to fix the boundaries in their respective villages of dispute which has been pending with regard to the boundaries as concerned, then the officer can determine the boundary marks as under section 139, cause a survey in terms of that agreement or in terms of that plan that is being made in resolving the dispute, showing the lands that is being claimed or showing that of the land that is being contended by the parties, causing a formal inquiry into the claims of the said parties, they can decide about the boundary marks. I repeat this, there can also be a question. Causing a formal inquiry is one such procedure for determining the boundary marks of the parties. Discuss, they may ask you the question. The same thing, whatever that we are discussing now is the same. In any way, they can ask you with the question. So, by causing a formal inquiry into this, the concerned officer or the surveyor can get into determining of the boundary marks of the respective village. So, this is one form wherein which by way of an agreement, the villagers can come themselves determine the boundaries of their villages and can resolve the dispute in respect of the boundary marks which they are having with. One. The second one is by way of arbitration. If several parties are concerned with the boundary dispute, not only the village, but if there are several parties who are there, maybe the holders of that, if they consider that it is necessary that the dispute they agree in submit thereof to the arbitration, then they can make an application to the effect in writing to an officer, that is to appoint an officer or nominate an officer so as to settle out the disputes of what they are having with. That is, they can go for a nomination of an officer to be appointed as a sole arbitrator or to form an arbitrator committee where in such case the majority of the members who arrive to the decision as whether they want to go by sole arbitrator or by the majority of the arbitrators, that is an arbitrator committee, then the decision shall be confirmed upon by that of the person, and in the due way that the officer can be appointed, that is an officer not below the rank of deputy commissioner, then deputy commissioner of land records shall be the final in that regard. If it's been appointed wherein not below the rank of deputy commissioner, then the deputy commissioner orders of land records becomes final. So you can provide for such officer to provide him and remit out the award in respects of that arbitration proceedings is being conducted. So in this way too you can have a settlement of your arbitration. That is where several arbitrators which is below the rank of deputy commissioner is been appointed. I was saying not below, it is not below, it is below the rank of deputy commissioner. Then the orders of deputy commissioners can become final in this regard. The officer below the rank of deputy commissioner can be appointed. So in this way, where if there are an arbitration committee, the majority of the arbitration committee, whatever that is been taken shall be considered and that should be decided with. Where if there is a sole arbitrator, where or an arbitrator of not less than 3 members fails to the effect of settlement of this dispute within the time that is been specified, that is even after going before the arbitrator, then the officer not lower than the rank of Deputy Commissioner of Land Records or the Deputy Commissioner himself can extend a time for settling out this dispute as otherwise provided. In a way, I can say, in a simple form, I can say you in this is that, see, the members who are being appointed for the settlement of this boundary marks with the dispute are concerned, they shall go settle out the dispute of not less than 3 months of time. Not more than 3 months of time, which is not more than of 3 months. I can, in another way, negatively speaking, within not less than 3 months of time, they have to decide with this, we say, but it is not more than 3 months of time. But if there is any such dispute has been taken place with, then they can go extend the time of this and they can settle how they dispute, provided where it also says that if there is an extension of time is required, the same can be made with an application for the extension of deciding of the dispute. So in this way, my friends, we shall see that the arbitration can be settled upon between the parties. So the two beautiful way is that one is by agreement or by the arbitration, or otherwise on the survey made and on the report that is been given to the boundaries are going to be fixed by the Deputy Commissioner. And what is the effects of this settlement of boundary? See, once when you go with the effects of settlement of the boundary, the settlement of boundary shall be determined on the basis, that is, by a proper partition. Once when this is okay, this is the boundary which we want to make, and if we say this, then the proper partition of the boundary line and mark should be made, and the right of the landholder who is being adjudged to either side of the respective holding shall be marked, fixed with the stones, or fixed in any manner, maybe with the board or with the stones or whatever the manner in the respective holding can be marked with respect to that of the respective holder. When the boundaries has been fixed, then the Tahsildar may also summarily evict all such person who happens to be in the wrongful possession of that property, or if is happened to be bound to hold such property which is not authorized to hold upon with, or if he is being adjudged as a holding of a person settlement, that is, if he has been adjudged that a person who is not required, who is not to be holding the property but is unlawfully holding the property, then he can appreciate on the same of the holding of any person through that of the claims that is being made, and he can evict the person from out of the property. That is also been provided to the Tahsildar. And under section 144 we shall see description of the boundaries are being given to with boundary marks. That is the description. When I say once when the boundaries are being formed out with, the boundaries can be constructed, can be laid down, can be maintained, can be repaired, or such divisional, in such manner, with such materials it could be made subject to the rules that is being framed out by the state government, the village on behalf of the Deputy Commissioner, on this behalf of the state government can order for the same, and it is the duty of every panchayat to take care of those boundary marks which it is being made. And the boundary marks shall be made by village accountant and the officers or the servants of the panchayats, and to prevent, and they have the duty also to see that there shall not be any alteration that is being taken place in that of the boundary marks. And any willful act, that is any person who willfully tries to remove, erase out or remove or injures the boundary mark, then a summary inquiry can be conducted against such person by the Tahsildar, and he can be imposed with the penalty for that of the act what is being done. And also the whatever that has been gained from out of the mark, the correction of the mark, the arrears can also be recovered by that of the person. So in this way, the boundary marks and settlement of boundary marks are going to be made by the person. So this is how settlement of land and boundaries and sites and villages and towns and cities of limit towns can be made upon with. One discussion I wanted to have you with. The second part of the discussion is the realization of the land revenue and other public documents. See, there is always a question which is asked in the examination is realization of land revenue is a paramount right of the authority under the Land Revenue Act discuss, they will be asking you. They will be asking you with this. Friends, why we call it as a paramount right is this. The reason is this, my friends. Once when there is an arrears of land revenue on your part, there is a creation of charge which is being created on that of the property because of your non-payment of land revenue. So in such case, it is necessary that every such authority, whether in both town and village areas, they have a right to recover such revenue what is being made. But the question comes is from whom you are required to recover the revenue. It is a paramount right, no doubt on that. It is the paramount right. That is, this right is absolute unless where the revenue is being exempted from the government. Unless where you are exempted, maybe under the scheme it could be, maybe to benefit out some welfare activities, or maybe to benefit out certain events which would be beneficial to that of the public. In such cases, the government shall have a power by its notification exempting you from payment of land revenue. But otherwise than this, whatever the revenue that is payable upon by you has to be paid by you in respect of those land issues are concerned. But who has to pay this land revenue? Section 157 of the Act provides saying thus, if the land is said to be an unalienated land, then the occupant of the land who is enjoying the land, except the tenant for that matter, we shall see that the land revenue has to be paid upon with. But if the land is said to be an alienated land, then the superior holder of the land is entitled or is liable to pay that of the land revenue. That is, the primary liability is on this person to pay the land revenue to the state government, and the payment of land revenue shall be made in accordance with what the state government has fixed to be paid a revenue on that of the land what you are enjoying. And all arrears of land revenue due in respect of the land shall also be paid to the extent of interest what you are holding in the land. But if the same is in case of joint holder who is happening to hold the land, then such joint holder are severally liable, that is jointly and severally they are liable to pay upon with the land. So this is the duty on the person to pay the land revenue of which is liable to be paid on that of the land. And why I am saying all these things is that when I started my discussion with the land laws are concerned in my introduction class, I was mentioning you with this that the land, though I am an absolute owner of the property, but the land vests in the government. I am only an absolute owner. The actual owner of the property is the state government. So state is the power, state is the authority, or the government is the authority which has a right over all those properties in the state. So, and I am given to an use with a particular kind of interest or with a kind of ownership in it, then we shall say that it is quite different. We have to pay the revenue on it. Whatever the manner in which I am holding, that's why I said it's quite different. Whether I am holding as a tenant or a mortgagee or whether an owner or an occupant, whatever it is, that to the extent of the interest what you are holding in, you are liable to hold this land and payable to the land revenue. If there is a default committed by a person, then the state government shall have a power under this section. When there is a failure, then the state government shall have a power to recover such land revenue from the person who is in possession. I mean to say, whether he is in actual possession or constructive possession of the property as concerned, he is liable to be recovered from such person. That is, a person who is not primarily liable to pay such is allowed to go on credit, and the payment may be made duly to the person on any other date as which is entitled to on credit, that is allowed to with. But otherwise than this, the payment has to be made by the person. So what we understand is that the state government, when a land revenue is liable to be paid upon with, they are entitled to collect that land revenue, and it is recoverable under the provision as by way of debt what a person happens to hold with the property, or by way of demand in respect of that property, or even they can go for the claim of that property. That is, whether it is in respect of the mortgaging, or whether it is by way of judgment or decree, or by way of attachment, or otherwise anything against to that of the holder thereof. They can pass in any of this manner, and they can have a power of recovering the land revenue on that of a person. That's why we say paramount right. When I say that the payment of land revenue, for the arrears of land revenue, the state holds a paramount right, is for this reason, because suppose if the property has been mortgaged to another person, where in which this property is again is with the dues of revenue payable to the government, then the state government, or the government, concerned government for that matter, will have a paramount right than that of this mortgagee. He shall have a right. That is why we say that this is the paramount right. All others may have an interest. Suppose if I have indebted the property, if I have taken certain loan on the property, mortgaging my property, against all those persons, the state government shall have a paramount right. That is the right of this person, that is the right of the state government, is a right which is highest than all that of the other persons who has a claim against the property. So the revenue, in cases of where the land revenue is liable to be paid on the current revenue year of the land for the, that is which is being used for agricultural purpose, and if otherwise it has not been discharged upon with, then it shall be recovered in preferences with that of the other claims on the crop of the land what is being grown. Sometimes we see that is it is recoverable on the basis of the crop of the land what is being grown. The land revenue shall become due. In fact, on the first day, we shall say on the first day of the completion of every year, that is usually we consider it is June 30th is the last day, and July 1st is the first day of the land revenue year is concerned. But when it comes to the land revenue rules 1966, this provides saying that the land revenue can be paid in 4 equal installments. It could be paid in 4 equal installments. That is on the 20th of the each month, that is from January to April, the fee can be paid to the village accountant. In this way, you can liable to pay the land revenue to that of the government. And how does the recovery of arrears go with? See, as I was saying you this, the land revenue can be taken by way of an installment, and or if any revenue is not being paid in part or full, they can prescribe a date for the payment of such land revenue, or they can also cause a notice to the person liable to make that payment who has been defaulted in such payment, or whose arrears has been balanced to that of the government. In such cases, they can go with. In spite of this, my friend, the process what they do is that to recover the money is that first is they give a writing in notice, that is under section 162, for the defaulter, calling upon the defaulter to pay the arrears of land revenue, and the officer who is being prescribed with this power, usually revenue inspectors, who is being prescribed with these powers, shall cause a notice or amount a notice due along with all those particulars as to the payment of the land revenue, and at least 7 days of the services of notice a person should be given time. That is, after the notice 7 days has to be given a time, and the person can be asked to pay it to the village accountant, and he shall make a report to the village accountant. In spite of this, the person does not pay, then the village accountant can report the same to the deputy commissioner. The deputy commissioner, so directed by the village accountant, so desirous of the default that is being committed, then he can go destroying the property, recover the property of movable which may be brought for sale by the revenue inspector after giving the publicity of the sale. This is the first forceful effect that what the deputy commissioner can take in recovery of the land revenue, arrears of land revenue. The second thing is that the forfeiture of occupancy of alienated holding can also be made. See, the Tahsildar may declare the occupancy of any alienated holding of the land in respect to which of the arrears that the land revenue is holding with, and its land can be forfeited to the state government. So also the land what is being forfeited to the state government can be sold and disposed of, provided the same thing, the Tahsildar shall not do so or shall not declare to do so unless where such occupancy or the holdings has been forfeited. That is, it shall cause a notice. Notice of forfeiture has to be made. Reasonable opportunity has to be given for a hearing, and unless of that they cannot go for forfeiture, or at least 15 days of the expiry of the notice they cannot take the steps of having even causing the sale or disposing of the property. But one more restriction is there to this, is that they shall not go declaring the land for forfeiture to the state government unless where the arrears of due of land revenue is not exceeding rupees 10,000. So with this restriction they can go for a forfeiture of land and disposing of the land too. Under 164 we see there can also be a sale of immobile property. That is, the Tahsildar may cause the defaulter of movable or immovable property to be detained with, and it can be sold by way of sale as that is being made in by the class of officers in this manner as it has been prescribed with. But however, we see a small exemption is being given to, that is where if any property which is kept exclusively for the use of religious purpose, or maybe I can say it is for the livelihood of each individual, that can be exempted from the sale or from the attachment also. Even CPC provides for this. In the same manner that could be exempted, that is the properties which are not liable for attachment we have. So in the same manner here too we can see that the property cannot be sold. That is, properties used for religious purpose or for their daily livelihood cannot be attached and sold in respect of them. So except of this can be more. That is in case of mobile. In case of immobile property also we see this Tahsildar shall have an option of processing the references, and it can also expedite in respect of selling of the property. That is, wherever if the Tahsildar comes to say that the non-payment of land revenue is an expedient to be carried out and it is insufficient for recovery of arrears, he may take an additional to cause a sale. That is, apart of selling the movable property, he can also proceed for causing a sale of immobile property which is being attached with. And how attachment can be made? That is, attachment can be made by transferring or by taking the prohibition of a defaulter in not paying the money. Then the Tahsildar shall make a notice upon them. Maybe the very oldest form was like beating the drums regarding with the forfeiture. But today beating drums or tom-tom has been no more in practice. Today what they do is that they come out with a notice making in the conspicuous place, and the notice would be made by the officer of this regard, and the same after making a notice they go with the attachment of the property what is being made. And the claims of the property, even if it is not being made within 1 year of the institution of a suit to be established, then they can go for sale of those property. And a person who is purchasing the property, when the sale is being made under it is confirmed by the Tahsildar, then the same shall be declared and the certification to that of the purchase is being made by the person could be also made. But if the same were to be an perishable goods, where the movable property is a perishable goods, then my friends, they can go by way of causing an action before all those things are being made and deposit the amount in the Tahsildar. So this is how they can go for the settlement of land revenue, recovery of land revenue from the part of the government. So this is how we can say that how land revenue can be recovered by the state government, that is deputy commissioner, by the Tahsildar, by the officer, by the Tahsil revenue officer, that is revenue officer, by the Tahsildar, and by the deputy commissioner on behalf of the state government. They can take steps in respect of recovery of land revenue. So this is one discussion. And finally, my friends, I'll be discussing to you with another important discussion which we have very briefly spoke upon, but I am bringing it in form of having explaining to you with, that is the power of the state government to make a rules. The question is something like this: explain the powers of the state government to make a rules under Karnataka Land Revenue Act. Friends, the state government may, by notification after the previous publication, shall have a power to make such rules and regulation with respect to the provisions of the Act or to carry the purpose of the objects that is being provided under the Act. So in particular, if you go, it says, without prejudice to the generality of the foregoing act and rules provided under the Karnataka Land Revenue Act 1964. It says that the state government shall have a power to make the rules in this regard. That is, I'll just give the list of the rules that it could go on with. That is to regulate the appointment of land revenue officers or other exercising, that is for the purpose of exercising their powers. All the land revenue officers we have seen right from divisional commissioner to the officers subordinate to that of the Tahsildar. In respect to all those revenue officers are concerned, the state government shall have a power to regulate of those appointment of the revenue officers, prescribe the terms and conditions, or I can say that is they can impose certain conditions or prescribe the terms and conditions on which the land revenue can be exercised, subject to which the village would, that is the village accountant would hold the interest in that of the property, would hold the office in that of the property. They can also make out the rules in respect of the village and village accountant too. That is how they hold the office. All these things can be given with. And here in saying that they can also prescribe the language on which the evidence is to be taken when any matter of dispute is being taken before. Or they can also prescribe the branches of tribunal that, as we said, or as we understood that headquarters now is as in Bangalore, but the state government shall have a power, the number of branches that could be made for the appellate tribunal. Prescribe the manner of appeal to be presented, the procedure we see from where to go. That is, prescribe the procedure for appeals. Prescribe the period for the application to prefer an appeal or revision, whether it's 60 days or 90 days. Prescribe the payment of land revenue to be made and it is out to be used with. Regulate the grant and permission of land for the individuals. Make a regulation in respect of the conversion of agriculture to non-agricultural land. Regulate the disposal of the land of forfeited land can be made. Prescribe the terms and conditions for which the period of an unoccupied land is unalienated may be granted with. What shall be the period it has been? Like we see, which is the rule of prescription comes in. Regulate the construction and laying out the maintenance and repair of the boundary marks. Prescribe the form of assessment and classification. Prescribe the manner of inquiry as how it has to be conducted by the Tahsildar, so also by the Assistant Commissioner and Deputy Commissioner. Determine the average yielding of crops. They can ascertain as what is the average yielding of crops. Then they can also prescribe the manner in which settlement report has to be made. Prescribe the procedure for preparation and maintenance of the revision of records of right, maintenance and revision in respect to the records of right, registry of mutation or any dispute or which is where it is in a disputed cases. Prescribe the form in which the records has to be maintained, tested in this regard. Prescribe the procedure for preparation of maintenance of patta book and fee payable on it. It can also prescribe the time and place of a person who could hold the land revenue shall be payable in what way, whether it is an installment or it is at one payment can be made. Regulate the transfer of cases from one revenue officer to the another revenue officer. Prescribe the administrative payment of arrears. All these things can be given by exercised by the state government. And the state government in making such rules under subsection 1 and 2, they can also say that any person who is committing a breach in respect of any specified under the act we see shall be also convicted and punishable with an imprisonment for the term exceeding not more than 1 month, and the fine of 500 rupees can also be imposed with this. The rule under this act is in fact made with retrospective effect, and such rules are being made with a reason to see that the rules shall be specified for the settlement before both the houses of the state and legislature if you are making the rules on this. So in this way, my friends, we shall see the rules. But in brief, I can say you is that the state government shall have a power to determine on administrative issues, to determine on the judicial issues are concerned. And how when I say determination of the judicial issue, right from the appellate board, right from the AC, right to the appellate board, they can have a right of saying who can exercise what power and what is the composition of the tribunal, all shall be fixed. When it comes to the administration, my friends, who are all the powers, what are their powers, what are the officers of these powers they are exercised to with, what all they can do, how marks are being made, how revenues are being collected with respect to all these things, they have a power of exercising with. So in this form, my friends, we shall see the state government shall have a power of carrying out the assessment. That is, they can have a power of carrying out the rules and regulation. They have a power to frame out a rules and regulation in respect of the Land Revenue Act 1960.